Thank you very much for that kind introduction. My name is John Muskin, and as Ian said, I'm a patent attorney. I work with lots of startups and the like. Basically, what I wanted to talk to you about is intellectual property and how it relates to startups. Basically, any startup needs to have some type of intellectual property coverage, whether it's patents, trademarks, copyrights. There's also trade secrets, right of publicity. I'm going to have an introductory lecture, go through all of these, and everyone's free to ask any questions you want. Just interrupt me whenever you have something you want to ask. It's fine. So first, I just wanted to start and describe the difference between patents, trademarks, and copyrights. I think some of you may have experience in these fields and some of you don't, so we're just going to start from ground zero. Basically, a patent protects an invention. Basically, Thomas Edison patented the light bulb. That's classic patent invention. A trademark protects expressions such as words, designs, or logos that are used to identify the source of products. So you see Coca-Cola on the shelf, you know what it's going to be, you know what to expect. Copyrights protect creative intellectual works. Song, movies, books, anything like that are copyrighted. There's a different legal procedure to get each of these patents, trademarks, and copyrights. Patents are kind of the hardest one to get. Trademarks, so-so, and copyrights are the easiest. So, and then there's a couple other less common forms of intellectual property. There's trade secrets, which if you have a secret that you don't want public, like the formula for Coke is a classic example of a trade secret, then you can keep it as a trade secret and nobody can publicize or take your trade secret as long as you keep it a trade secret. If you publicize it or leave your formula on the bus or something and someone gets it, then it's no longer a trade secret. So there's some ways you need to protect your trade secrets to keep them confidential. And then rights of publicity is also less common, but basically people can't use the likeness of other people for free. There was a famous case where someone made a greeting card. Hallmark used Paris Hilton in a greeting card, and she sued. And she kind of won, then they settled. Basically, you can't really go around copying Elvis or anyone like that without some type of agreement with the person who you're copying or using their likeness. But today's lecture, I'm going to just focus on really the first three here, the patents, trademarks, and a little bit about copyrights. Before I continue, any questions about any of this? Shoot. Yeah, the USPTO is the United States Patent and Trademark Office. So that, trade secrets, you don't really file trade secrets. You just kind of keep them secret. There's no real, there's no registry to register a trade secret. So, There's another question? Go ahead. That's an excellent question. Patents are good for 20 years from filing. So once you get a patent, you've got the patent's public, it's a published document, and after that 20-year term expires, it's in the public domain, anybody can make it. So the owners of Coke figure they can keep it a trade secret, nobody would know about it, and then they have it, indefinite length of their protection, where nobody knows the secret, and so they get protection for hundreds of years. So, yes. Yeah, and I can't figure out, if anybody knows the answer to this, please chime in, but why can't some chemist just analyze Coke and figure out what the formula is? I never could figure that out. If anyone here a chemist can answer that, because, all right. Yeah. Really? But was it the same, did it taste the same as Coke? Oh, okay, interesting. He said put rum in it, that was the comment. So what can be patented? Basically most anything, any process, machine, article of manufacture, composition of matter. Some Supreme Court case said that almost anything under the sun that's made by man can be patented. Now, I get a lot of questions as whether you can patent a business method. Historically, yes, there's some debate now whether you can or you can't. The courts are kind of struggling with patents on business methods as we speak. So it's something that's being resolved right now. So in theory, yeah, you can patent a business method. There's no prohibition, but there's a big movement now to not allow patents on these sorts of things. So it's kind of in flux right now. Go ahead. Oh, good question. Okay, like a way to lend money. Let's say I'm making stuff up here, but you do a credit check on somebody, and You look at maybe the zip code they live in, and you see if they live in a fancy zip code, maybe they get more money. You give them a better loan. So that's kind of a business method type of idea that people try to protect. You know, money being transferred left and right. Okay. There's 3 types of patents. There's a utility is the most common type. Utility patent is where you have an invention, like any engine or electric circuit or a new kind of cup or anything really. A design patent protects how something looks. Design patents are very easy to get. If you designed a new article of clothing, a new ornament of jewelry, anything, and it has a unique appearance, you can file for a design patent and protect how it looks so nobody can copy your design. And then a plant patent protects varieties of plants. Don't worry about the plant patent. I've never had anyone file a plant patent with me, so I'm not worried about that one. I'm sorry? Oh, okay. All right. We'll have to talk after this lecture. Okay. Either. It has a unique shape, that's a unique design, or maybe a logo embroidered on it, that's also unique. Anything that's unique has a unique appearance, right? So it could be either the shape or just what's printed on it, sure. Okay. I have some wacky patents here I wanted to share with everybody just to give you an idea of, when they say you can patent anything. This is one of my favorites. It's a dog. I'm not even quite sure what you call this thing, but it's animal ear protectors is the title of it. And it's so your dog's ears don't get wet when they drink water out of their bowl. So you put, yeah. This dog, he'd get made fun of in the doggy park, that's for sure. So, here's a second one. Is a method of exercising a cat. This is now this was filed in 1993, and you'd think somebody before that would have done this. Basically, what this patent covers is you shine a laser, one of those laser pointers, and you have your cat chase it. And yeah. Some people who are critics of the patent office point to this as what's wrong with their patent office right here because they issued this craziness. So here's this is a good example of how the patent office doesn't care whether an invention is commercially viable or not. They just care whether it meets the requirements, to get a patent. This is a cure for the hiccups. It's a cup that gives you an electric shock when you drink out of it. So, yeah, I'm not going to use this thing. This is a very, very famous patent. This is Edison's patent, patented in 1880. This is it, just 3 pages. Despite what most people think, he didn't invent the light bulb, he improved it. The light bulb existed back then, but he used a carbon filament that made it last much longer. And so this is the entire 3-page patent that he must have made millions or, I don't know, hundreds of millions off every light bulb that was made for this patent term. Everyone cut Edison a royalty check. So that's it. 20 years from filing. It's in the public domain. Any invention. No, you can't. Then everybody, now when you buy a light bulb, Edison doesn't get a royalty anymore. It's in the public domain. So, this is, anybody know what these shoes are? Yeah, a mistake, right? Yeah, that's a good answer. This is the name of a design patent where you protect what something looks like. And yeah, these are ugly shoes. What? Oh, it was issued in 06. It was filed in 04. And design patents are very easy to get, like I said, as long as your design is unique. So they've made a lot of money off these shoes, so they have the last laugh, not us. So, so what are the main requirements to get a patent? There's a lot of requirements. I'm sorry, go ahead. Just the design. How it's made doesn't matter. It's just you make another shoe that's going to look like this, then you're going to infringe this patent, and they'd sue you, which they have. They actually sued people on this patent for knockoffs. So, in the U.S., if you file it in the U.S., it's the entire U.S. country. If you file in a foreign country, it's country by country. So. Well, that's a good question. Basically, it depends how different it is. If you make it and you may change something just tiny, then it's going to still come under the patent. The more you change, the more likely you're safe from not infringing this patent. So it just depends on how close you are to copying someone's design. So, shoot. Mm-hmm. Really? Mm-hmm. Was it by Crocs? But it looked like that? I know Crocs sued some people on their patents, and that may have been the party they sued. Oh. Well, they may have trouble with this patent. I don't know. It depends how close it is. If it looks really close to this, they may have a problem with Crocs. I don't know. So. Oh. Okay. Yeah, if it's different, then they're probably okay. So there's a lot of requirements to get a patent, and this is why you typically hire an attorney to take care of all the red tape for you. But there's two major ones that we'll talk about that are most important. The rest is pretty easy to satisfy. One is pretty much common sense. An invention has to be novel. It has to be new. Obviously, you can't file a patent on something that's been done before. If you file a patent on that light bulb that isn't invented, you'll get a rejection right away, of course. So the other big requirement, and this is a real important one that attorneys struggle with the patent office, this is what we do for a living, is an invention has to be considered not obvious to one of ordinary skill in the art by the patent office. Now, what's obvious and what's not is very subjective. So this is what patent attorneys do is you file a patent, they will reject it most of the time at first. They reject 95% of patents right away. That's just how the game is played. And then the attorney goes back and tries to argue why the invention is not obvious over the other patents that they found they thought was the closest patents. And so, again, it's very subjective. You get a nice examiner, he'll allow your patent. You get someone who's a real jerk, he may not want to allow it. It's just, this is number two is really what we spend a lot of time with when we apply for patents. And then a patent search is usually recommended. Basically, if you have an idea or a concept, you are generally recommended to doing a search at the U.S. Patent and Trademark Office databases just to make sure that nobody else has done the same thing or there's nothing else out there that is obvious, or very close to it that would render your invention obvious over it. So a search is not required, but it's usually recommended. Mm-hmm. That's a good question. The question is sometimes you do a search, but different names have different synonyms, and it's always hard to find what you're looking for. And it's just the PTO has classifications and subclasses. Like they will divide maybe like a laser pointer into a certain class and subclass, and you would search for that class and subclass, and regardless of what you call it, it would still be classified under that subclass and class. So that's one technique we use to try to get around that issue. Any other questions? So here's a recommended invention workflow. There's no real right or wrong way to do this, but this is generally what we recommend. Is first, first step you think of the invention, of course. Then we recommend doing the patent search. Once in a while, there may be situations where you don't want to do the patent search, but for the majority of times, you do want to do the patent search. And then you can build a prototype of your invention. It's optional. You don't need to do a prototype to file a patent, but it's very helpful. So you see if your invention works right, how it may work, how it functions, and what it looks like. Then you file the patent, and once your patent's filed, then you can go ahead and market your invention. Of course, once you file the patent, the PTO stamps your date that you filed it on it, so they know when you filed it. And once you file it, you're locked in your filing date, and then you're free to go and disclose it and market it and not worry about the patent because it's already been filed. So, any questions on this? Is very important. Shoot. The question is, when you build a prototype, does that serve as proof that you're the one who helped create or invented it? Yeah, I suppose it would help to build a prototype but you can have witnesses. You can sign an invention notebook, then have witnesses sign it saying you're the inventor. They just changed the law recently, and now it's we've changed the law to first to file. So it's really whoever gets the patent office first and files their application first gets the patent. So you really want to file your application first and not worry so much about proving who invented what. Just get it filed. And as long as you filed it before somebody else, and you get the rights to it, with some exceptions. But yeah, actually, yeah. There's I don't know how true this is, but it's been documented that Alexander Graham Bell filed a patent on the telephone 5 hours before somebody else did, and so Bell got the invention. But actually, the old law was the first to invent. Whoever invented it first would really get it. And I assume that Bell actually invented it first, and that's why he got the patent. But we've recently changed to first to file, so whoever files the patent first would get the patent. So, well, I'm sorry, what's the question? The first to invent was a mess because somebody could file a patent, and years later somebody can come out of the woodwork and say, I invented this before you did, and get into whole legal litigation and big mumbo jumbo. And so it's really easier to do first to file. Then once you file it, you know when you filed it, and it makes it much more simple and locked in. So there's pros and cons of each way. So, okay, so you filed a patent, now what? There's a few ways to make money from your patent. The most common one is you license it. Those of you who watch Shark Tank, O'Leary is always saying, like, someone's got a patent, we're going to go and license this to some company and we'll get a royalty. And yeah, that's typically when you get a patent, you'd go license it to, if it's a tool, you may want to go to Home Depot or a tool, Black & Decker company, that's the best way and easiest way. It's also very, very hard to get a licensee. Just a lot of companies aren't eager to take on third-party products, but they do it from time to time. It's just hard. Number two is even harder. When you have an issued patent, you could sell it to somebody who wants the patent. And of course, they're not going to buy it unless they really need your invention for whatever purpose they're in. And then three is even more of a longer shot, is if you have a patent and you haven't licensed it or sold it, one day, a patent's good for 20 years, so someone may come around and make the same product, and then you can really sue them for infringement, or then give them a license and say, look, you got to license this patent from me, otherwise you'll be sued. So these are really the three main ways you would get money out of a patent. Any questions? Okay. All right, this is the patent application process. Very simplified, of course. The manual of patent examining procedures over 1,000 pages. So this is just a very oversimplification, but basically you file the application. Typically, as I said, the USPTO sends initial rejection. They'll find the closest patents they find, say the invention's obvious, and then the attorney, writes his own response and explains why the invention is not obvious. And then this can go back and forth, as many number of times as it takes until either the examiner allows it or the inventor just gives up. But eventually, if the examiner allows the application, then they issue the patent. Mm-hmm. Yes. There's about 6,000 examiners at the patent office, and they're broken up into different art units. So if you've invented, let's say, a new kind of article of clothing, it would go to the clothing unit, and they would be like experts in that field, and they would make the determination of whether they think it's an obvious invention or not. And it's very subjective. No, it's one person. It's one examiner. You're assigned to one examiner, right? And then if you can't get anywhere with him, then you can appeal it to a board of appeals of the patent office. That's a longer, different process. But yeah, it's one person. I know it could drive you. It's maddening, actually. You get somebody who's real difficult, and it's a maddening process. And this leads me to my next slide. It is just about a month ago, there was one patent attorney who just got fed up with some of these examiners and couldn't take it anymore. So when you fight the rejection, you're filing like a brief, a very official legal document with the patent office. It's not like a light matter. It's kind of a serious, affair. And so this attorney here just got fed up. And I always get a laugh when I read this letter. This is what he fought. Does any volunteer want to come up and read this? Any volunteers? Come up. Read this in your best voice. Okay. But can you read it from here because you can't.
Okay. Are you drunk? No, seriously. Are you drinking scotch and whiskey with a side of crack cocaine while you're examining patent applications? Do you just mail merge rejection letters from your home? Is that what taxpayers are getting in exchange for your services? Have you even read the patent application? I'm curious, because you either haven't read the patent application or you are, I don't want to say the R word, special. Numerous examples abound in terms of this particular examiner not following the law. Clearly, the combination of references would render the final product to be inoperable for its intended use. However, for this special needs examiner, logic doesn't cut it. It is manifestly clear that this examiner has a huge financial incentive to reject patent applications, so he gets a nice Christmas bonus at the end of the year. When in doubt, reject, right? Since when did the USPTO become a post-World War II jobs program? What's the point in hiring 2,000 additional examiners when 2,000 rubber stamps would suffice just fine? So tell me something, Corky. What would it take for a patent application to be approved? Do we have to write patent applications in crayon? Does a patent application have to come with some sort of pop-up book? Do you have to be a family member or some big law firm who incentivizes you with some other special deal? What does it take, Corky? Perhaps you might want to take your job seriously and actually give a shit. What's the point in having to deal with your Special Olympics? Special Olympics rejects when we should just go straight to appeals? While you idiots sit around in bathtubs farting and picking your noses, you should know that there are people out here who actually give a shit about their careers, their work, and their dreams. Your job is not a joke, but you are turning it into a regular three-ring circus. If you can't motivate yourself to take your job seriously, then you need to quit and let someone else take over that actually wants to do the job right.
Great job. You have acting experience? It was a good job. Rumor has it this attorney is now being prosecuted for some ethical violations for sending this letter. So it doesn't surprise me. So this guy just lost it. A month ago. Yeah. If you Google Andrew Schroeder patent, it's all over Google. You'll find it. So Andrew Schroeder patent, yeah. So, is there a question? Sure. Good question. Yes, you can to some extent. You can change what you're trying to cover. You can't add anything new into it, but you can change the coverage that you're trying to get. So if you find something similar, you can try to amend your claims to try to cover something a little different to try to get your patent granted. That's a good question. Mm-hmm. Well, some patents are published 18 months after filing, and some aren't. You can choose if you want it published or not. If it's published after 18 months from filing, then people can comment on it. If it's not published, then there's no comment period until it's actually issued as a patent. So, okay. So, just a few takeaways. I mean, patent law is a very complex field. Just a few important takeaways is from this lecture is one is it's best not to disclose your invention until a patent application is filed. This is for obvious reasons. If you go around on TV or whatever, on Shark Tank or whatever, and tell your invention, somebody else can file a patent on the same thing, and they'll be filed before you. And there's some limitations to that, but it gets kind of messy. It's always best to file your patent first. So you really don't want to disclose your invention until a patent's filed. Number two is also very, very important. If you've publicly disclosed your invention, the Patent Act states you have 1 year to file a patent. It's a very harsh rule, especially for those who aren't really that familiar with patents. But if you miss that 1 year window, then it's too late. You've lost your invention, at least the rights to patent it. So if you've sold one or gone on a street corner on the internet and disclosed your invention, make sure that you file the patent before that 1 year expires. And then number three is just fact of life. Most patents don't make money. So it's never that easy. Some people call me and they think they got the best idea ever. They expect to file it and make millions the next week. It's never, ever that easy. It takes a lot of hard work. I mean, people do make money with their inventions all the time, and I'm sure we have a lot of successful inventors in this room, but it takes a lot of hard work and a lot of patience to get an invention marketed, produced, and sold. So, any questions? Okay. We'll talk a little about trademarks as well. Basically, trademarks protect the source of goods. A service mark is the same thing as a trademark, but relates to a service instead of an actual product. You can also trademark slogans such as "You deserve a break today," "Just do it." Basically, when you see a trademark, you know the source of the goods, so you know what you're getting. Anyone see a problem here? Maybe those of you in the back can't see. It's a knockoff of a Sony radio, but it's SQNY. So basically, I'm sure Sony has some good lawyers and they took care of this product right away. But basically, Sony has a trademark on Sony, so they'd have this product removed from the shelves. They could sue whoever made this thing. They can have it prevented from being imported and all that. Yeah. Right, that's correct. That's called typo squatting. It's a different... Well, right. Someone owns that site, and no, you can't sue that person who owns Google because he added first, I think, and he's not trying to trade off Google. So it's just kind of fortuitous that just leave it alone, right? If now if somebody, that's a good question. If somebody came along and registered like GOOGLES or something like that, and tried to make a search engine out of it, yeah, that would be a trademark infringement. Sure. The name of it's called typo squatting, where you actually make a typo of a domain name, but it is trademark infringement. Yes. So. I'm not so sure. It's just so close to Sony. I don't care how you make it. You do it in pink with crazy font. It's just so close to Sony. I don't think that you'd get away with that. So, it's the same font. Of course, they're trying to trick people. But yeah. Mm-hmm. Here's an example of some trademarks. Believe it or not, Subway has a trademark on footlong. Yeah, I was surprised to see that. But there's one called Dead Lawyer for mugs, mouse pads, T-shirts. I don't know how I feel about that one, but the last one is kind of a Hooters competitor called Restaurant, where it's like a bikinis type of bar where they have women in bikinis serving food, and so these are just examples of the things you can trademark. Most aren't so amusing, but and then there are some reasons why to pursue a trademark registration. I'm sure a lot of people hear about businesses, and you've got names for your business and products, and basically, you get a nationwide scope of protection. So there's one central federal trademark database where if you have a trademark, you're in that database and everybody knows about your trademark. So it's really something, it's a no-brainer. Any legitimate company will file trademarks on their names and their products. It provides a prima facie evidence of the validity and existence of the trademark rights. It shows a priority date of when you first started using it. Can lead to incontestable trademark status. If you use a trademark for 5 years continuously, then you basically have a bulletproof trademark, and nobody can really, try to have your trademark invalidated. And it's also a very good deterrent against infringers and potential infringers. You have a trademark that's issued, people will probably stay away from it and not want to fight with you in the court. How do you register a trademark? Basically, you either must be using the mark or have a bona fide intent to use it. We recommend a trademark search to make sure that nobody else has a similar trademark that you want to file. You file the application with the USPTO. The USPTO will examine it, and they will determine if there are any other confusingly similar marks out there. And if they have confusingly similar marks out there, then they will not allow the registration. And then the attorney, again, will argue again why it should be allowed. And then if there's no confusingly similar marks, the USPTO will then publish the mark, and then people have a chance to oppose. If they find a trademark offensive, they can object and see if the trademark will not issue the registration. Yeah, that's a good question. The R means when the trademark's actually registered. The TM is when it's been filed or not even been filed yet, but you're still claiming a trademark use. So when you say TM, they still claim a trademark, but it's not actually issued as a trademark. When you see the R, it's officially registered as a trademark. So
nobody in the USPTO had seen that Restaurant was offensive?
Oh, well, I guess it's a matter of opinion, isn't it? I mean, I don't find it offensive. I don't know. But to some. Well, I'll get to that. There's another mark I wanted to... these are some famous trademark fails. Regarding offensive, someone found, going back to... someone in the news lately is O.J. Simpson. Going back to 1994, he filed right when he was in prison, but it was pretty much looking like he was going to be acquitted. So he filed a bunch of trademarks called O.J. Simpson, O.J. the Juice, for clothing, dolls, pictures, trading cards, games, and someone objected saying it was offensive. Someone just found it offensive that he would, I guess they didn't think highly of him. I'm not going to comment on Simpson himself, but so they alleged to be scandalous, and they actually got far in their objection. Then Simpson just gave up the fight. So certain marks, people can find offensive, and they won't register them. But I guess restaurant, nobody really found that offensive. Donald Trump tried to register "You're fired," and And it just goes to show, even if you're Donald Trump, you can't circumvent the law. Someone else had a trademark on "you're hired," and so they didn't allow him the "you're fired." So, Dunkin' Donuts tried to register best coffee in America, and I think it's clear why they couldn't get that mark. I mean, I think everyone. well, that too. That's not what I meant, but I mean, you can't register trademarks that are descriptive, because then nobody could say we have the best coffee in America if they granted this trademark. So I don't know what Dunkin' Donuts was thinking when they tried to register that, but there's no way they would grant that trademark. Any questions so far? Shoot. They didn't register it? Day of the Dead. Oh, it's a Mexican holiday? Oh, maybe that's why they... Yeah, you can't register like common... Yeah, that's a good one. I'll have to look that one up. So you had a question? That's a good question. A trademark could lose its trademark status if it becomes generic. I think Kleenex actually is generic now. I think they've lost it because everybody uses Kleenex. So yeah, I think now that's a good. I'll look that one up, but I think it's now lost its trademark status and it's generic. So you can say Kleenex and not worry about, Procter and Gamble coming after you now. So Xerox too, I think is generic too. Frigidaire, that's generic? No. Fridges, yeah. A little about copyrights, and then I'm going to wrap this up. Basically, just copyrights protect books, paintings, movies, anything that's kind of artistic. You can see the difference between a patent protects an invention, a trademark protects a name, and the copyright protects just a work of authorship. It's very easy to get a copyright. You just file it with the U.S. Copyright Office, and it's very rare they will reject it. There's 3 requirements. It must be fixed in a tangible medium, written down, recorded, photos, anything that's just tangible. It's got to be original, and it's got to have some creativity, but the bar for creativity in a copyright is very, very low. So even like a picture you take of this room, just the angle and the lighting would probably satisfy to be a copyright. Term is 70 years after the death of the author. So a lot of famous artists and authors, after they're 70 years dead, then their stuff becomes in the public domain. And any questions on this? I think it's like $35 to file a copyright. It's very cheap. Just send it in. Trademark, the PTO charges $325 to file a trademark plus the attorney's fees. Shoot. Go ahead. I disagree. Now, roughly, the cost for a patent depends on the complexity of the invention, of course. A simple like pen cap might be in the low end of the spectrum, and a real complex like computer technology would be in the high end, but you're looking anywhere from maybe $3,000 to $4,000 for a very simple invention to maybe $10,000 for a very complex invention with an attorney. So, well, probably is the patent office found it to be an obvious invention. The PTO doesn't like to issue recipe patents. Like it sounds like it's like a recipe patent where you can combine a few ingredients and you market it as like a food product. And they usually say those are obvious, just easy to mix ingredient A and B and C and make a compound like that. So they're very hard to allow patents on food stuff like that. They do allow them, but they're very rare. So, but the 100,000 is crazy. I don't know where you got that number from. You should find a different attorney. So, yeah. Too late. That's a good question. It depends on how it's registered. You can protect both the words, like Sony, S-O-N-Y, and also a logo, too. If you've got a logo, you can file 2 trademarks, one on the word and one on how the logo looks as well. So. You couldn't object, but you couldn't be prevented from using your name. Like Sony can't sue you for using your name, Sonny. So, I mean, so, yeah. You'd have a problem with Sony, absolutely. So, what they're copywriting there is just basically the look and feel of the site and the content. It might have words and articles and the colors and logos, and that's what they're protecting is just how that looks. So you couldn't copy that page without somebody objecting to it. I would assume that any reputable package you buy, like Front Page or whatever, would give you the rights to use their templates in your own, assign the copyrights in the public domain so they wouldn't have a claim against you. So I would assume that any package you buy is going to have in the terms that saying you're free to use these and they're not copyrighted. So I'd assume. I mean, it's possible that a package could reserve the copyrights for themselves, and then there would be a problem there. So, yeah. Mm-hmm. You don't need to use the symbols. It just puts everybody on notice that you have a trademark or a copyright, so people might just not step on your toes. But if you don't use the symbol, it's not really... I'm sorry? Yeah, exactly, right. Mm-hmm. You can patent a recipe, but it's in theory, but in practice, the PTO is rare to allow those. Their position is that you combine like you ever make your own mixed drink in college where you put some rum in and some Coke and some vodka, and it's just so easy to mix ingredients that... Mm-hmm. You really wouldn't have a legal problem. It might have a moral problem taking someone's recipe, but well, you should be an attorney then. But then legally you wouldn't really have a problem with that. So. Mm-hmm. The originality requirement is very, very de minimis. So if it's anything different at all, just file the copyright again, and you shouldn't have a problem. Really, what year was this? Really, I'm surprised. I don't know. I'm surprised. Usually they don't really reject applications very often. It's very rare. So. Mm-hmm. Well, intellectual property is just kind of a catch-all term that includes patents, trademarks, and copyrights. So, yeah. That's kind of a patent you file that doesn't meet all the requirements of a formal patent. So if you're like on a budget and you want to file a really quick patent real quickly and easily and cheaply, you can just write it up yourself and file it. There's a lot of pitfalls with that approach, but I can't, there's no time to get into that now. But it's something that you can file on your own if you really want to get something filed with the patent office real quickly. So. I think it's really crazy not to file a patent, and the reason being because you have that 1-year window I mentioned before. So if you have a product and you don't file the patent and that 1 year goes by, if it's the most successful product in the world and you're selling millions of them, you can't get the patent after that 1 year. And then people can come and knock off the product. So I think that really it's a no-brainer. You really should file at least some kind of patent just to get it on file. And whether it's easily replicatable or not, it's just something I wouldn't really worry about that up front. I would just file the patent and just so you're protected and not worried about it down the road. So. You can't trademark someone else's novel that someone else has written. Is that? No, someone came up with a dictionary for the J.R. Rowell. What are those books that? Harry Potter. Yeah, someone came up with like a Harry Potter dictionary and used all the terms in the Harry Potter books, and they got sued by Rowling or whatever her name is, and they lost because you can't really use someone else's terms and artistic expressions that someone else has come up with. So that would be an IP violation most likely. So one more slide, and then I know we're short for time, is just copywriting. My last slide. Do not download movies for free over the internet. I get a lot of calls all the time from people who had subpoenas served from their ISP. So, basically you download a movie, your ISP can get a subpoena from the copyright owner trying to find your identity so they can file a suit against you. A real common movie was The Hurt Locker. They were really going after people who were downloading that online. So they could file a suit against you. Your name could be like on some Google site somewhere. You don't want to get mixed up in that. It's also a criminal violation to infringe someone's copyright. So just don't. That's a good question. I don't know. I would pay the $5 and just do it legally, but I don't know. That's a good question because you're not really copyright. You're not really copying it. You're just watching it. And it's streaming, so you're not really copying it. So that's a good question. I don't know the answer. So, question? And that's basically my lecture. So anyone has any questions, feel free to email me or find me on LinkedIn. And